Good day, ladies and gentlemen, and welcome back to another What If video. From our side, compliments of the season to you. We trust that 2022 will be a great year. So in today's topic, I will be unpacking when do independent contractors become employees. We see it quite often that in independent contractors referring or rendering services to a business or a company, when their contract is ended, they refer a dispute to the CCMA or Bargaining Council claiming unfair dismissal, which we know cannot be the case because an independent contractor is not covered by our labour laws. However, in some cases, this independent contractor may be seen as an employee. Therefore, the question is, how do we determine whether an independent contractor is an employee or not? Now, the term employee is defined in both the Labour Relations Act as well as the Basic Conditions of Employment Act and other labour-related legislation. However, the term independent contractors is not defined in any legislation. In general terms, an independent contractor is someone who independently renders specified services or produces specified products or results to a number of clients. Essentially, an independent contractor is someone who runs a business of some sort or another. Now, it's critical to distinguish between employees and independent contractors since, number one, only employees are protected by the provisions of the LRA, BCA and other labour legislation. For example, unfair dismissal, unfair discrimination and exploitation. This means that whereas the contract with an independent contractor can be ended as provided for in the contract between the parties, employees can only be dismissed if the substantive and procedural requirements for fair dismissal have been met. Also, only employees are entitled to basic conditions of employment as stipulated in the BCA, for example, annual leave, sick leave, maternity leave. Employers of employees are also liable for any unlawful acts committed by their employees in the course and scope of their duties, whereas no such liability rests in respect of actions of independent contractors. Now, while employers are obligated to deduct income tax from the remuneration of the employees, true independent contractors are responsible to personally pay their own income tax directly to SARS. Now, whether a person is truly an independent contractor as opposed to an employee would depend on the circumstances and the facts of a specific relationship. Section 200 capital A of the LRA and Section 83 capital A of the BCA provides a list of factors which, if any one or more of the factors are present in any specific relationship, creates a presumption, until the contrary is proved by the employer, that the person rendering services is in fact an employee, not an independent contractor. And I think the important point there is that it is any one or more of the factors as listed in Section 200 capital A of the LRA or Section 83 capital A of the BCA. Now, ladies and gentlemen, this presumption is only applicable to individuals who are earning less than the earnings threshold, which is currently around 211,000 Rand per annum. Where a person earns in excess of the earnings threshold, the factors listed in the sections nevertheless remain relevant and should still be considered in determining the true status of the work relationship created between the parties, although no automatic presumption will be created. Now, in the case of a person earning less than the earnings threshold, the person will be presumed, until the contrary is proved by the employer, to be an employee of the person to whom services are rendered, where one or more of the following factors are present. Number one, the manner in which the person works is subject to the control or direction of the person to whom services are rendered. Number two, the person's hours of work are subject to the control or direction of the person to whom services are rendered. Number three, in the case of a person who renders services to an organization, the person forms part of that organization. Number four, the person who has worked for the person to whom services are rendered for an average of at least 40 hours per month over the last 3 months. Number 5, the person is economically dependent on the person to whom services are rendered. 6, the person is provided with tools of trade or work equipment by the person to whom services are rendered. And then finally, the person only works for or renders services to one person. In the case of employees earning in excess of the earnings threshold, the following additional factors are usually taken into account to determine someone's employment status, although no automatic presumption is created. Number 1, the object of the contract between the parties is for the person to render personal services. Number 2, the person to whom services are rendered may choose when to make use of the services of the person. Number 3, the person is obligated to perform lawful commands and instructions of the person to whom services are rendered. Number 4, the contract between the parties terminates on the death of the person who renders the services. Number 5, the person to whom services are rendered provides training to the person in respect of business methods. Number 6, the person receives fixed payments from the person to whom services are rendered over defined, consistent periods, regardless of outputs or results provided. And finally, the person belongs to the organization's pension fund or medical aid scheme, or qualifies for any other type of benefit. Now, in determining whether a person is an employee, our courts and CCMA are more interested in the factual nature of the relationship between the parties than the specific label attached to the relationship by the contract. Should an employer treat a person as an independent contractor under circumstances where the person is in reality an employee, the employer is placed at risk, since it is not providing the employee with those benefits employees are legally entitled to, and furthermore, no income tax will be deducted from the person's remuneration, exposing the employer to tax problem. Further, on termination of the person's services, the employer might face a claim of unfair dismissal, since it in all probability would not have followed the correct legal procedures in terminating the person's services. Employers, to minimize their risks, would therefore be well advised to make sure that they are properly informed about the exact legal nature of the relationship with those rendering services to them. Ladies and gentlemen, that brings us to the end of our first What If video in 2022. It's an interesting topic, but it's also a complex topic. If you need any assistance in this regard, as always, please do not hesitate to contact us. Until next time, bye-bye.